All right, folks, it is time for our favorite podcast, Cut to the Chase, compelling legal news. And, right now we got a big one. SCOTUS, Justice Breyer resigning at the end of this term. And I'm a big fan of Justice Stephen Breyer. In many ways, his philosophy, I think, kind of is my philosophy in life, and pragmatic and all that. And so I figured, oh my God, I got to get somebody on here who can, give us the deets. And so I brought in Professor Rodger Citron. How are you doing today, Rodger?
Doing great, thanks.
Full disclosure, I know Rodger for, I'm going to say 3 decades. Rodger and I have met through a mutual friend who's also been on this podcast several times, David Chase. And I love this guy. We're not tight, but I do. We connect, and I love you. So
Perilously close to 4 decades, if we're really going to lay it all out there for the listeners.
4 decades, and I'm a math guy, and that's crazy. All right, so I want to cut to the chase, although I have not yet cut to the chase, and get into this gentleman, Justice Breyer. Rodger, actually, I want to give a little bit of his background. He's a professor at Touro Center. He's been a professor for 17 years, teaches a lot of things, including civil procedure and administrative law, which we're going to go into a little bit in one of the major decisions, doctrines that we're going to talk about with Justice Breyer. And he's also been an associate dean since 2014. So, and I will put his bio in case you want to read more about it in the show notes. So let's talk about Justice Breyer. So give us some basic facts of his background.
One of the things, I did a little bit of research before our conversation, and my favorite Justice Breyer fact, if you will, about his biography is that by the age of 12, he was an Eagle Scout. And he's only lived up to the promise of that accomplishment since then. He extraordinarily able and intelligent lawyer, very impressive career. He clerked on the Supreme Court after law school. He did several government stints on his way to becoming a judge. He also was a professor at Harvard Law School. I think most relevantly, when we think of him today in terms of his biography, he was nominated and confirmed to the First Circuit in 1980. This is a really interesting fact that no way it would happen today. Confirmed after President Reagan won the election in 1980, which meant that there was really bipartisan support for his nomination and appointment to the First Circuit. Fast forward to the Clinton presidency, Clinton's first vacancy, Justice Breyer, then Judge Breyer, was a finalist for the spot. You may remember, because we are, if we've known each other for almost 4 decades, old enough to remember that Breyer had a bicycle accident before his interview with President Clinton for that vacancy. He went and did the interview. I think he injured his rib. He has said afterwards that he was in great pain, and apparently the interview didn't go very well. So that nomination went to Justice Ginsburg. But the next time there was a vacancy, this time President Clinton did nominate Judge Breyer, and he was confirmed in 1994 and served on the court ever since. So that's a capsule bio of Justice Breyer. And he also, it's important, as we'll get into, at Harvard Law School, he taught administrative law. And he's not only written articles, but written books about that subject. And he's a central figure in the court's jurisprudence in that area in a number of ways. So next question.
Next question. Thank you. You know I have no patience. All right, next question, but it's a follow-up. All right. So you're talking about how the bipartisanness of his getting onto the First Circuit Court of Appeal.
Yes.
So explain what you mean. Like he's nominated, and then the
So
new
yes.
Go ahead.
President Carter nominated him for the position, and at the time he was serving on the Senate Judiciary Committee, and at that time, Senator Kennedy, Senator Ted Kennedy, Senator Orrin Hatch, I think were key figures on the Judiciary Committee, and we've had a situation in which even when there was a Democratic president, the Senate didn't move on Merrick Garland in 2016, I believe it was. President Reagan gets elected in 1980, and the Senate nonetheless moves forward and confirms Breyer to his judgeship on the First Circuit. And nowadays, it just seems like the reaction politically would have been, well, your president lost, our president won. That's the end of the road. That's the end of the nomination. And yet, because he had such a good reputation, and this is actually sort of I think an underknown or underdeveloped fact about Justice Breyer. That is, he was very good in forging relationships with people and getting along with people. And so it was not at all controversial. It was not contested in 1980, so that he was confirmed by the Senate after the election. He started on the First Circuit in 1980 after the election. And that's a story from another time.
Yeah, and back then, presidents would, put somebody as justice, and then all of a sudden they wouldn't rule the way they were expected to. But nowadays, I don't see that happening. I think that is a shift that has passed, and that might be unfortunate. But all right, so the second thing that I want to talk about, just laying the cards out so we can build on this discussion, is administrative law. Justice Breyer taught administrative law. You taught administrative law. I do civil law, and everybody knows what criminal law is. Civil law, you're suing typically for money, for the most part. I mean, you can sue, for other things or whatever, but for the most part, it's money. Criminal law, we know that. What is administrative law? Like, give me just like the nutshell description of this.
Yes. So administrative law, I explain to students when they ask what the course is about. It's the law of government agencies. So that alphabet soup of government agencies, many of them established during the New Deal. For example, the Federal Communications Commission, Securities and Exchange Commission. Administrative law refers to the laws and procedures by which those agencies do their work. There's something known as the Administrative Procedure Act, and there's plenty of judicial decisions, case law, interpreting the Administrative Procedure Act. And then when you teach the administrative law course, and this is absolutely relevant to understanding Justice Breyer's work on the court, you have judicial review of agency action. And that takes you into questions like, is the agency's interpretation of a statute reasonable or permissible? And that's the Chevron case that I know we'll get into. Is the agency's action reasonable or supportable? That is to say, is the agency's action, the challenge that would be made to it would be, for example, with the adoption of a seatbelt requirement or an airbag requirement. The agency responsible for that, is that action arbitrary and capricious, or on the contrary, is it reasonable? So you're really talking about how agencies do what they do, and whether the things that they do, whether they're supportable legally.
Yeah. So you have local agencies, you have state agencies, you have federal agencies.
Yes.
And on this show, just to kind of put things into context, because I know that everybody listens to every show repeatedly. So that, oh yeah, no, I know what you're talking about, administrative law. The two agencies we talk about often on my show are the EPA, the Environmental Protection Agency, and the FDA. And everybody, you've been to everybody. If you haven't heard about the FDA, I don't know what planet, you're obviously not living on this planet. Maybe you and Elon Musk or somewhere out of the orbit or whatever. But so from what when I was kind of writing my questions, I was going to do the show, I wanted to talk about the Justice Breyer's philosophy before I went into the cases that we're going to talk about. But I almost think that it's better to lay out the philosophy through his cases. And I kind of want to, and I'm like, all right, and I see you have a lot of paper over there too, so don't be laughing or whatever. But let's stick with, the Chevron Doctrine. Let's talk about that in the context of what it is vis-a-vis his judicial philosophy.
Yeah, Chevron, the joke that some administrative law professors, and I include myself as one of them, make to their students is, long after you've taken this course, probably the only thing you're going to remember is 2 steps, Chevron. And Chevron is a case decided in the mid-1970s. The author of the opinion was Justice John Paul Stevens. And Chevron, it involved the EPA. It involved regulation, a change in the rules with respect to air pollution, I believe. And so the key point that comes out of Chevron is, and the reason why it's sort of the anchor of the administrative law course is, so Congress passes a law, and sometimes the law is clearly understood and generates a clear understanding, a clear meaning. And when someone sues about agency action taken pursuant to that law, if in fact the law is clearly capable of being understood, we say at Chevron step 1, it's a question for the court, and there's a clear meaning to the statute, and the court, as a matter of law, says the statute means what it says. That happens sometimes, but anyone who is familiar with the legislative process at any level knows that compromise is part of the process, and that compromise sometimes takes the form of language that's used. Sometimes it takes the form of things that aren't addressed, right? We can't reach agreement on a contentious question, so we don't say anything about it in the law. In that situation, when you have something like the congressional statutes like the Clean Air Act and other statutes that authorize agencies like the EPA or the Food and Drug Administration or the Federal Communications Commission, where I worked before becoming a law professor. Well, if the statute's ambiguous and the agency says, well, we interpreted the statute to permit us or to authorize us to take the following action, the way that plays out in court when there's a challenge is that the agency will say, well, the statute isn't clear, there's an ambiguity there. Under Chevron at step 2, because there's ambiguity, the court should defer to us as the agency in interpreting that law, in applying that law, and we get deference. And so as long as what we've done is reasonable, the court should uphold our actions. So that's the core, that's the Chevron holding, if you will. And the principle that it reflects at step 2 is the idea of deference to agency action. The agencies are experts in what they do, and they should, be deferred to. There's also an argument for those of you who are political theorists, right? The agencies, they are the president's agencies. We elect the president. We don't elect anyone on the courts, the federal courts. The agencies are more politically responsive. That's another reason for deferring to the agencies. So that's the concept of Chevron. Nowadays, there's some question as to should we continue to adhere to it? Should we modify it? There's even, I think at least one or two members of the court, perhaps more, depending upon how you understand what they're saying, who are saying maybe it's time to set Chevron aside, this two-step approach, and come up with something different. So we're talking about Chevron, and that'll take us into, Justice Breyer had some nuanced thoughts about Chevron.
Yeah, I mean, we could talk, and I do want to touch on, well, if not Chevron, what? But this is about Justice Breyer. So let's talk about his take on the Chevron Doctrine. I mean, the case became known as the Chevron Doctrine. It's that significant of a case. But what's his, has he made any comments like, I like it, I don't, I wrote this doctrine, whatever?
Yeah, so he of course came to the court well after the case had been decided. And I think there's, I'll try and keep this answer relatively short. Two things that I think are important. One is, I think that you go through Justice Breyer's judicial decisions, his approach to administrative law. And the first point is that he was generally sympathetic to the principle of agency deference, That is to say that, the agencies know more about what they're doing, what the nature of what they're trying to regulate, what the purpose of the regulation is, and so on. And so he generally was sympathetic to that sort of core principle of Chevron. Nonetheless, the nuanced piece to this is that there were times, I think, when he felt that Chevron is sort of applied too generally and too broadly. There are certain circumstances in which it's not obvious or clear that the issue before the agency is one on which it has expertise. And so in that situation, he very well would, might say, we don't necessarily have to defer to the agency in that situation. There's an interesting wrinkle here, and maybe it's helpful. When I teach the course, the administrative law course, I say to the students, you're going to see there's really a fundamental divide between Justice Breyer and Justice Scalia. And we can talk about that. The irony is that Justice Scalia, who in many ways, was the antithesis of Justice Breyer, he actually felt, oh, Chevron, having it apply broadly, simplifies things. If we can all live in the same Chevron universe, we know how things work. And so there's clarity. We have the benefit of all knowing how it works. And so there's almost an irony there that in some ways he was a broader or a supporter of a broad understanding of Chevron in a way that Justice Breyer wasn't always.
All right, so let's hold for one second there. Just want to put together a couple more pieces. First of all, like when they talk about agencies and all this, I mean, the chief executor is the president.
Yes,
You have the courts, you have Congress, and then you have the president and all the agencies, FDA, EPA, FCC. So the president could also issue like an executive action, and that essentially could be challenged almost in the same, not exactly along the same lines as Chevron or whatever, but that's almost like an agency kind of administrative law type of that falls within that umbrella, is what I'm saying.
Oh, yes. And so just I would say it as, right, we have, this really takes you back to, and again, I say this in class, right, Schoolhouse Rock.
Yeah.
We have Congress, the legislature in Article 1. We have the president and the president's officers or agents under Article 2. Those are the political branches. And then, of course, we have the courts, the judicial branch in Article 3 with the Supreme Court at the top. Those are different branches of government. And, that's the way we set things up in 1789 with separation of powers as a core principle.
Okay, so just to kind of put it all together, the EPA and all this stuff, and how we get to the Chevron decision or whatever. So Congress can basically pass a law and say, all right, FDA, you've got to regulate, you got to protect the air, you got to protect the water. And then the question is, well, oh, does carbon dioxide, is that part of our jurisdiction or not? Well, we think it is, and we're passing this, and then people challenge it. And so all these kind of decisions get kind of funneled down to Chevron. Congress, and the courts, are always battling or whatever, who is in charge. So going, and that is sort of one of, I think, Breyer's big issues is which branch of government should be resolving the particular issue. So, all right, now I want to go to sort of like Scalia versus Breyer and the judicial philosophies. And we can kind of tie back to Chevron, move on to another case. Just everybody's like, oh, Scalia, originalism, textualism. What is Breyer? Does he have like a term? Is there a term for his philosophy?
The word that has appeared over and over, and I think it's an accurate one in the profiles and so on of him now after having made the retirement decision, is pragmatic or pragmatist. And it makes for a nice contrast with Justice Scalia because Scalia, in being an originalist, and I don't know if this necessarily falls from being a textualist, but there is a formalistic, somewhat rigid aspect to Justice Scalia's approach, in the sense that, with originalism, you're focused on, well, how did they understand the Constitution, in 1789? And Breyer is associated with what's known as the living Constitution school, with the understanding that, right, we live in a very different society now than we did in the late 18th century. And we need to be flexible in terms of understanding that society is different and adapt the Constitution, to our current situation and conditions. That means, the law can evolve. It's okay for courts, for judges, to try and make sense of an 18th century document, the Constitution, or a 19th century document, if you want to put the Civil War amendments in there, in light of current conditions. And the pragmatic piece is, I think he was always very much concerned with, making things work in a sensible way, interpreting statutes in a sensible way. So that's, I would say pragmatist is the word most commonly associated with Justice Breyer, and I think appropriately so.
Yeah, I mean, it's really such a fascinating topic. When you think about originalism, I know Scalia was often asked, and I think they actually debated it or maybe talked in front of the Senate about this question. Listen, the Constitution, there was no planes, trains, automobiles, there was no cell phone, no NFTs, no cryptocurrency. So how does, why should the, Constitution, determine these things that were obviously not even on people's radar, as smart as the people that wrote the Constitution are. But then you go back to the fact that, all right, well, we're basing our decision on this particular that's what the law says. So you're, as this is played out, several centuries are now, we're now, I guess, seeing that there was, maybe they didn't anticipate the writers of the Constitution just didn't anticipate how this is going to play out,
Yeah. Well, one view is, they knew, they didn't think they knew that they weren't coming up with all the answers in perpetuity. And so they understood that we're setting up a structure here with the understanding that time goes on, society evolves, and these are guidelines, or this is a word you'll sometimes also hear with Justice Breyer, right? Standards. And I think he was very comfortable, as long as you're being self-aware about it, with, well, yes, the court, when it engages in the act of interpreting statutes, interpreting the Constitution when there was a constitutional challenge, of understanding that in the moment, now, in this case, it's the court, it's the judge with the authority to make this interpretive decision. And we have to make it because it hasn't been previously resolved or addressed. And that's what we live with under the Constitution. That isn't nearly as troubling to him as it may be to a stout or hardcore originalist who would say, oh, but there's this risk. The judge is just going to make it up and do what the judge wants, and that will be unmoored or not anchored to any authoritative legal text like the Constitution.
Yeah.
So that's an ongoing debate. A colleague of mine at the law school, I think you can find it somewhere on PBS. They sat for Breyer and Scalia sat, and they did one of these sort of mock debates with each other, and each absolutely knew what the other one believed, what the key points were, what the key points of disagreement were, and they would do it in a very good-natured way. It's actually kind of charming if you can ever find it.
Yeah, and is this the one with the joke about the bear running away from the bear?
I know the joke. I'm not sure if that's in the recording that I've seen, but I know that the joke is out there. I know the joke is out there, right? Which is, you should tell the joke since you know it better than I do.
No. I mean, it's Scalia's joke, and that somebody comes up to, I don't know, I'm so bad with jokes. I'm much better being funny than telling a joke, but I'll try. Like somebody comes up and says, "Oh my God, this bear is after us," and these two guys are together, and so, "Oh my God, there's a bear," and they're looking at each other, and they're like, "We can never outrun the bear." And then the other guy says to him, "Yeah, but I don't have to outrun the bear. I just have to outrun you." And that was Scalia's sort of take on this debate about, all right, maybe you got me on the originalism. Maybe it's not a, bulletproof philosophy, but I don't think there is either on either side, So going back though to Breyer, because we're talking about Breyer, pragmatism, results oriented, trying to look at the law, like what is this law trying to do? All right, maybe it wasn't written the best way.
The purpose of the law. Yes, I just have to say that word because that's very important. Yes.
That would be it. Okay. So now I want to move on. All right. So last question about Chevron, then we're going to move on to the next case. Does it survive? I know there's a couple of cases that, they're always trying to challenge Chevron or whatever. Does it survive? And if it survives, if it doesn't survive, is there a clear, okay, then we move on to this kind of doctrine? I don't even know. Yeah.
There's different ways to think about what we could do in a non-Chevron world or in a minimized Chevron world. There's a case that Justice Souter wrote the majority opinion for the court. It's called Meade, and it has to do with letter rulings by the Customs Service. And without going into all the detail about the case, the idea was, well, let's take a sophisticated approach to an agency action determination rule. And by that he meant, well, how much deliberation went into the agency action? In what way did the agency issue its action? Did it do it after an informal rulemaking process? Was it the result of an adjudication? Or was it just a letter that someone wrote? And the idea was that in Meade, Justice Souter was saying, while still maintaining that Chevron was law, we can be more nuanced and sophisticated about how we understand what the agency did, so that then when we have to decide, do we defer to the agency action? And if so, how much? That would give you more of a facts and circumstances approach in making a determination about how much, if any, deference the agency action deserves. And there's an older case from the 1940s, I believe it's called Skidmore, that that the Meade case draws on very much. So one alternative, right, if Chevron has, endorsed, and Justice Scalia, by the way, in the Meade case dissents. He says, you're making a mistake. You're making a mistake because you're making things, too complicated. What lawyers really value is clarity and certainty. And the genius of Chevron is 2 steps, right? If I can't answer the question at step 1, that the statute clearly, means what it says and can be clearly interpreted, then I go to step 2 and I give deference to the agency. And Scalia's argument was, we all benefit in that world, even if sometimes the decision might not be the best decision. We all benefit from living in that world because of the certainty and clarity that we have from knowing that. Just 2 steps. Justice Souter and Meade, different factors, how much weight, balancing, all these types of things. You might get to the best answer in a case. What do you do in the next case? Start all over again with, well, I have to take into account the following factors. So that's one way to go here. There's another, which kind of gets into this question about, some people call it Chevron step 0, which is, well, really, is this a question on which the agency has expertise? Shouldn't that be an integral part of the analysis? And how far do we go in sort of saying, the agency really it shouldn't be considered expert here, or shouldn't get deference. My own view personally is, I think that there's a real force to Justice Scalia's Chevron. The power of Chevron is that it makes life more manageable, more clear, all things being equal, for all of us. So we'll see. There is, with the court has turned over. I think the oldest justice on the court now, I believe it's Justice Thomas, right? And that goes back to, that was an appointment made in 1991. There's no one on the court now who was on the court when Chevron was decided.
Yeah.
So it may become an artifact, but it's not clear how that will go. It's a hard, it's easy. It might be easy to criticize. It's hard to come up with a better approach.
All right. So there's 3 other cases I want to talk about. Just one of them I think fits in the administrative law world, which is the employer vaccine mandate case that just came down. Where did, was he involved in that? And does his philosophy kind of show up?
Yes, Breyer. So that's the OSHA mandate case that the court set aside recently, and Justice Breyer dissented. And in his dissent, this is where I think you get a real sense of him as an administrative law person. That is, someone who worked in government, someone who taught the subject, who's written books about the subject. And he really felt like that the invalidation of the OSHA order was wrong, in part because he was confident that I think OSHA had the authority to do what it did, and I think just as important, he felt that the public interest would be served by such a rule or such an order or requirement, and some of the language in his dissent absolutely reflects this idea of, government is capable of acting in the public interest, and it should be, it should receive deference or respect when it does so. And I say this, I may be oversimplifying this a bit, but remember Ronald Reagan, right? We talked about the election in 1980 and Breyer's confirmation. Reagan, I hope this is an accurate quote, but I know it's an accurate paraphrase, right? I think during the campaign, he says, when someone says, I'm here from the government and I'm here to help, those are the most terrifying words in the English language, or, one should be concerned about that. And that's, at a broad level, that really is, I think, that's where you sort of see this difference or disagreement between, someone like, say, Justice Breyer and someone like Justice Thomas. for example.
Okay. All right. So next case, and this is not really a case I think that is, people think maybe are going to be surprised here about it. Brown versus Board of Education, 1954. I thought that ended the whole, you got to desegregate schools. But, apparently 2007, we have another big case that is directly on point with the Brown decision, parents involved in community schools versus Seattle. Tell us about that case, what he did, why was
Yes, this is a
and
case that has, it was a big deal in 2007. And you had two cases before the court. One was from the Seattle School District. The other one, I think, may have been from Louisville. It's in the case, whatever it is. The caption, of course, is the Seattle School District case. And there, the school districts, with the goal of trying to promote demographic balance in the student body, took race into consideration. And it was fairly, nuanced, but nonetheless, it is the case that the school districts did say that under certain circumstances, race would be taken into account in the assignment of students to a particular school in these two school districts. And the court held that that was unconstitutional, a violation of the Equal Protection Clause, that was an illegitimate use of race in that context. It was a 5-4 decision. It was a 5-4 decision. And the five, led by Chief Justice Roberts, we would consider, the conservative bloc, or and Justice Breyer. This is, I didn't realize this until I was reading for today. Longest judicial decision of his career, a 77-page dissent. And there is even an account of his reading it. That is, you can go back and read in the New York Times. Linda Greenhouse recently wrote something about this. Breyer read his dissent aloud. And for someone who is thought to be, sort of cerebral, academic, almost detached in a certain way, he became emotional reading the dissent. And what he felt was that the majority decision was, I don't know if he uses the words exactly, but essentially a betrayal of Brown. And he felt that the idea of Brown in 1954 was, to offset, to combat school segregation, and that the use of race here by these school districts was entirely consistent with the holding in Brown, the purpose of Brown. They were for remedial purposes. And so it's a very powerful dissent. And as I say, there was even, as one of my colleagues would say, a performative aspect to it, that his reading it in court absolutely drew press coverage, called attention to the significance of the case. So that's a very interesting case.
Yeah, you sent me, before our show today, you sent me an article, I think it was from the New York Times, about his questioning. And I didn't really sit through a lot of his, oral arguments or whatever. So it was kind of interesting, that he asked long questions, and some of the questions that he would ask, I think are you familiar with those stories at all? Because those were pretty funny, some of the questions really were, I don't want to say out there, but they were, ephemeral, I guess. I don't know.
Yeah, there are for a couple cases, like important cases in civil procedure or administrative law, I have read the transcripts of the oral arguments, and he would, if you've ever seen the transcript of an oral argument, that it's double spaced, right? In other words, you're reading, there's a question by a justice, so it indicate Justice Breyer, and then there's the lawyer responding, and sometimes you'll see that there's Justice Breyer, and then there's like a broken dash where the attorney starts to answer, and then Breyer keeps going, and then the attorney thinks, oh, now he's done, and it can go on like more than half a page until Breyer finally says, okay, that's the question. Now answer it. And the thing that really impressed me in those situations was, there's several thoughts about what goes on in oral argument. That is to say, I think what Breyer was doing was, in good faith, really trying to get to the core of the, of the case or the core of an issue, and get the attorney's, best answer to that issue. That is, it was exploratory or inquisitive. Now, there's another aspect of oral argument, and you don't see Justice Breyer, I think, doing this as much. But someone like Justice Scalia, he was actually, the purpose of the colloquy in oral argument was he was actually trying to persuade another justice. And so he was actually arguing through the colloquy with the attorney with another justice on the court. And I really, from that article that I sent you, as well as from what I've read, I didn't see him doing that as much. I really think he was trying to, get to the center, get to the heart of the matter. It just took him a little while.
Yeah.
It articulated the question.
And I've been reading. I'm not a Supreme Court scholar or expert, but because we're at the moment, I've been reading articles or whatever, and it really amazes me. Two things that when you say that the judge is an oral argument, you would think when they're asking a question, but they can do whatever they want to. They could sit there and pontificate. There's really no, like I go to court if I'm, not properly asking a question. It's like, you've already asked that question, counselor. I'm like, I know, but I didn't get the answer that I wanted to. All right, now, I can, I'm sitting here getting, but they can. And then I think I read that there's actually no code of ethics for the Supreme Court justice.
It's entirely up to them. Yeah. That is, they are responsible for enforcing whatever the ethics rules or whatever, whatever the, rules, requirements, issues that come up. It begins and ends with them.
Yeah, as my relatives would say, oy vey. But all right, no, I try, listen, hey, they're at the top. They're as ethical as can be. All right, so now I want to get into our last topic, and you can't really talk about a justice without talking about abortion rights.
Oh boy.
And so was he quiet? Was he loud? Was he in the, was he dissenting? Where was he on this, on the major abortion decisions in his time?
As we've talked this through and getting ready to talk to you, I really feel that we might have a strong argument here that he's really an underrated justice, Justice Breyer. And the abortion cases highlight that in a way, because in the last couple years, when it was still the Kennedy court, right, when Justice Kennedy was the swing vote before he stepped down and was replaced by now Justice Kavanaugh, abortion was as close an issue. The decisions were almost always 5-4, and the question was, how would Justice Kennedy vote? And so, in a number of decisions in the last decade, one of them is the Nebraska partial birth abortion case. That's known as, I think Carhart is the name of one of the parties to the case. There were also 2 decisions involving, admitting privileges at the hospital. These were laws that were passed as a way of trying to restrict the availability of abortion. And in those 2 cases, one in 2016 and one in 2020, Justice Breyer really, drove the court in these decisions because he really took seriously, well, is there or is there not an undue burden by the state law on the constitutional right to abortion, such as it is? And if that was the undue burden standard was what was articulated by the court in 1992 in the Casey decision. And what's really impressive about his work in those cases is, and this is really almost drawing on his administrative law expertise and how things work. It was really almost an empirical investigation into, what are the circumstances? How will this day in and day out affect the availability of abortion, in the area where the hospitals are, and so on. And so even though, I think the conventionally, in the law school setting at least, we associate abortion with Roe versus Wade and Justice Blackmun. We think of the Casey case in 1992, in which I believe it's Souter, Kennedy, and O'Connor come together to try and, to reaffirm the validity of Roe as precedent. And yet here, as things are, as the right becomes increasingly under pressure, that is, the right to abortion becomes increasingly under pressure, you see Breyer within the existing legal framework, leading the court to take seriously the right to abortion and getting 5 justices to say that, in fact, there's an undue burden here and striking down these state laws. There's now pending at the court, there's a Mississippi case that was argued this term. There's a Texas case, which has a confusing or complicated procedural history and complicated procedural aspects to it. This may be as good a place as any to at least start to come to a close, because now it seems like, right, the score isn't 5-4 with Kennedy being 5, the score is 6-3. The score is 6-3, and that's Breyer is one of the 3 in dissent. And so, these cases that, Roe versus Wade and Casey, we really don't know how much longer they'll still be the law of the land.
Yeah. So normally, judges will make decisions on complicated questions. They'll say, you can't do this unless there's an undue burden, or it has to be reasonable. And then then if you're thinking, well, what the hell is reasonable? Well, there's another 1,000 appeals that are gonna, because all these facts and this is reason, is that reasonable? So the judges in a lot of opinions where they come up with a standard will set forth factors that will help courts to decide whether something is an undue burden. And from what I understand, Breyer in his abortion rights decisions at least was part of, or maybe even at the forefront of defining what that is, instead of leaving it up to the courts. This is an undue, this is not. He set the 24-week limit as the answer to what's an undue burden?
I don't think so. These cases that I'm thinking of, I think are after that determination, as I understand it.
Okay.
But that's, anyway, I think I'm right, but I just want to hedge there just a little bit.
All right, so let's go back to your 6-3. Now Justice Breyer is resigning. We're going from 5-4, whatever that means. I mean, it's sad that we're even talking like this. It sounds like we're almost, playing a sport.
Yes.
The presidents are putting younger and younger justices in, and the obvious statement really is this one's going to be here for 40 years. So, don't worry about it. So really, there's a lot of talk who's going to replace Justice Breyer. Is it going to be an African-American lady? Which one? Blah, blah, blah. And my question to you is, in your opinion, and obviously things can happen. Who knows what's going to happen in the world of law? But do you think his legacy? Do you think he'll have an impactful legacy on future jurisprudence? I'm going to give it to you in the broadest.
Yeah, I absolutely do, because, and this is kind of consistent with, I feel like he's underrated. And the reason why is there's certain decisions, we think of certain justices being associated with certain decisions. So Harry Blackmun, of course, is Roe versus Wade, which I mentioned before. Justice Brennan, for me, I always think of, I think New York Times versus Sullivan. And Earl Warren, you think of Brown versus Board of Education. And then you also think of the criminal procedure cases like Miranda. And I think that on the day that Justice Breyer retired, if you had said to someone, name the definitive Justice Breyer decision, I think they would have been challenged to come up right away, unless it was something that they already knew from what they taught. And yet, in what we've gone through today, which is a number of important administrative law decisions where his thinking absolutely has relevance, that whether we call it pragmatism, that will, I think, and that also that idea of deference to agencies, I think that will continue to be influential. We've talked about, it may be that these decisions, these majority decisions he wrote in the abortion context, they may become the basis for dissents if Roe and Casey are overturned. We also, it's entirely conceivable to think of that Seattle School District dissent as being what one of my professors used to call a canonical dissent. That is a dissent that, becomes influential in the future because it lays out a way of thinking and a set of ideas and an approach that could be influential in the future. But the last piece, and really we have to hope that this aspect of Justice Breyer endures. Some people said at the end, oh, he's so naive. He's still here talking about the court as an institution. It's not political. What planet does he live on, or what court is he on? It's for the best for all of us. I think he absolutely understood. He knew what political life was like, and he knew how politics worked. I think it's important for all of us to keep in mind that, this whole thing, the rule of law, these things that we say on the first day of orientation in law school, we have to think about the law that way. And when you said, 5, 4, 6, 3, and we should, it's a shame we're talking about things that way. That's true. We should be talking about the court and the law, even as we know, that there's a political aspect to it, or there's political aspects to the court. For the law to be authoritative, for the court to be authoritative, we have to believe in the institution and the rule of law, the institution of courts and the Supreme Court. And that was an integral part of who Justice Breyer was, and it's an important part for us to aspire to, as difficult as that might seem nowadays.
And those will be the final words of this episode, folks. I can't do any better than that. Listen, Professor Citron, my friend, thank you dearly for coming on and talking about this topic.
It was my pleasure. Thank you so much.
And that'll be it for this episode of Cut to the Chase. I'm going to have the professor's bio and link on the show notes in case you want to dig deeper into who he is. Okay, everybody, have a good day. Go out and hug a stranger. How about that? That's my call to action. All right, hug and kiss a stranger. All right.
All right. Thank you.